College of Arts and Social Sciences at the University of Rwanda. I'm going to be the moderator, and I wish to welcome you to the second Salon in the Transnational Justice Project Critical International Law Salon series. Today's theme is Instruments of Justice. This conversation and the series more broadly engages with themes that will be explored in the inaugural Transnational Justice Project Summer School, which will be held from July 18th to July 23rd, 2022 in Rwanda. The summer school is open to advanced students in the social sciences and law, and is intended to bring together faculty from academic institutions around the world to engage, debate, and collaborate on topics related to critical international law. Registration for the summer school is limited and closes on December 31st, 2021. And this is an opportunity to invite you who are following us online or who will watch this conversation later to share the call for application to those who may wish to attend the summer school to apply in time. Today's conversation engages with capacity and suitability of various legal instruments in addressing injustice when faced with the aftermath of massive violence or gross violations of human rights. Some turn to the law in the pursuit of justice, and although there is a place and time for legal instruments, when used at the wrong time and for the wrong context, they can be seen as blunt tools for addressing deeply socio-political issues. For this webinar, panelists will reflect on case studies in relation to various legal, socio-economic, political tools, and will also consider other justice tools ranging from religious cosmologies to the arts and narratives. A few logistics before I introduce our panelists. The format is one in which our guests will integrate their research and expertise in a candid conversation among colleagues. This will be followed by a Q&A session from the audience. In the process, I will be interjecting some questions or making some more follow-up questions to those from the audience. Please feel free to use the comment section to pose questions and indicate whether you are posing the question to a specific guest. And finally, a recording of this webinar will be available on the International Summer School Salon page just a little while after the event concludes today. So let me briefly introduce our guests. Joining us today are Professor Phil Clark, Ms. Florida Kabasinga, and Dr. James Nyawo. Phil Clark is a professor of international politics at the School of Oriental and African Studies, University of London. He is a political science specializing in conflict and post-conflict issues in Africa, particularly questions of peace, truth, justice, and reconciliation. His most recent book is Distant Justice: The Impact of the International Criminal Court on African Politics. Phil, you are most welcome.
Thanks, Alphonse. Delighted to be here.
Florida Kabasinga is a Rwandan private legal practitioner with nearly 2 decades experience in the field of international criminal law and domestic justice in Rwanda. She has spent 12 years dealing with international criminal law, 9 years with the Office of the Prosecutor working as a trial and later as the appeals counsel at the International Criminal Tribunal for Rwanda, and 3 years at the National Public Prosecution Authority of Rwanda dealing with extraditions and advising on the international criminal law. She's now a managing partner of Certa Law Chambers in Kigali. You are welcome, Florida.
Thank you, Alphonse, for that kind introduction.
James Nyawo is a lecturer at Kenyatta University, Nairobi, Kenya, in the Department of International Relations, Conflict and Strategic Studies. Prior to joining academia in 2009, Dr. Nyawo worked in the humanitarian sector with several international humanitarian agencies in Angola, Uganda, Sudan, and South Sudan. It is from such experience of working in the humanitarian emergencies that he developed an interest in criminal accountability for those atrocity crimes. His doctorate focused on the dynamic relationship between the International Criminal Court and Africa. He has published a book based on his doctoral findings. The title of his book is Selective Enforcement of International Criminal Law, the International Criminal Court and Africa. He also edited a book, International Criminal Justice in Africa since the Rome Statute. This is in addition to publishing several book chapters and blog posts. His recent blog post discusses pros and cons of President Omar Bashir facing an ICC trial in Khartoum, Sudan. You are most welcome, James.
Thank you so much, Alphonse. I'm so happy to be here.
Yeah, and welcome to you all, our distinguished panelists. And I believe that everybody agrees with me that we cannot have a better composed team to discuss this topic we are having today. Before we go into the subject matter, it is important to reflect on the fact that this Salon was supposed to have taken place last Friday, on 3rd December, but we were made to postpone it to today because of ongoing strikes that were taking place in UK. And I don't know, maybe Phil, you would be interested in discussing that as an instrument of justice, and how does it look like when ideas of justice compete?
Thanks, Alphonse. I think it's only appropriate, given that we're going to discuss issues of responsibility and accountability, that I take responsibility for the fact that today's panel has been delayed by 1 week. Last week, we were striking on most UK university campuses because our pensions, our salaries have been slashed and our work conditions are getting tougher by the week. Today, talking about instruments of justice, I think we're going to talk a lot about doing things. Well, last week with the strikes, I think we saw an instrument of justice that was about not doing things. It was about downing our tools, denying our labor, and trying to exert some pressure on the policymakers and decision makers of the UK to make UK universities a much healthier space for staff and students. So in its own way, I think those strikes were an instrument of justice, probably just an instrument of justice very different from the ones that we're going to talk about this evening.
Thank you very much. That was fair enough. In this conversation, I will just for, these are not like guidelines, just to have a flow of information. In this conversation, I will have the first question that I will run to all of you, the three of you, and then after which I will have one specific question for each individual, in which each other panelist may want to comment on. So to begin, I would like to ask this question to all of you, starting with you, Florida. How do we assess the appropriate instruments for justice process?
Thank you. I think on this panel, I'm probably the one who is purely a practitioner of international criminal law, and I have not actually been in that space for a while. I think the last interaction I had with it was the beginning of 2016. But I think actually, let me applaud whoever is behind this series for this format, where you have a conversation and just exchange ideas about your experience and all of that. And I think how you assess it, to be quite honest, most of the time, a situation happens and everybody is scrambling to figure out what the best instrument should be. And a lot of the time, because in a situation of mass atrocities, everybody wants to do something to get justice somehow. And a lot of things, I think, a lot of considerations fall through the cracks. And sometimes the policymakers and the people that are making the decisions are not familiar with the situation. And so they tend to tailor make, to use the instruments that they are familiar with for situations that are sometimes need a completely different solution. In the world, we all come from different legal backgrounds with different influences. And so most of the time, everybody thinks their own instrument, or the instrument that is used mostly by them, is the best. So, the crimes we are talking about, mostly like genocide, crimes against humanity, war crimes, are viewed as crimes against the entire world. And so when you try to tailor make an instrument, you literally are thinking these crimes were not committed just, the victims are, I mean, theoretically, yes, the victims are all humanity, that's true. But then behind all of that are real victims, are real people who are impacted, are real witnesses who saw what happened, and are real people with stories to tell, with lives to live, no matter how they've been impacted. So when you're thinking about these instruments, I think all of that needs to be taken into context, the cultural background, the influences in that country, how are you tailoring the instruments to the situation to actually, in fact, help the country and the people somehow get out of that situation, or have some kind of lives that are going to somehow improve from that situation. So then, but the level at which these conversations are happening, or what the instruments are, I think most of the time, the power is actually taken out of, the people that are actually impacted. These things are being discussed at UN level, at UN Security Council level. Each country has its own interests. There are people that have their own, powerful people that have their own interests. And so you have all these things that are competing that need to actually be taken into account. And I tell you this not because, because of the experience that I have. After the 1994 genocide, obviously you have a population in Rwanda that is affected. I believe everybody was affected in one way or another. And obviously, since the tribunals in Nuremberg and all of that, we hadn't had a serious discussion on what instrument should be, used in this situation. International criminal law basically had not been developed. So you have people trying to create something literally without having a prior experience of how it should be done and how best to do it. And then you have a mostly population that is uneducated, that are the victims, that are the witnesses, that have no experience going to the kinds of courts that were being discussed. And you end up creating an instrument which is very useful in the end, I think, but which is completely foreign, and people just, the people that are involved just don't understand it. You're taking victims and witnesses from their country and flying them on an airplane for the first time. And these things may sound a bit strange to people, but you have people that have never asked for passports in their lives. And then you put them on an airplane with people that speak a completely different language. You take them to a completely different context. You put them in front of a courtroom full of foreigners, speaking a completely different language and not understanding your context. you try to explain something to them because they're viewing it in the context from where they come from. And then you realize they actually don't believe your story because the things you're talking about sound alien. You're talking about maize fields and sorghum fields, and people they have no clue what a sorghum field is. So I think, to be quite honest, with the experience that has passed on instruments and how to deal with these things, although like in Rwanda, you had different instruments that were used at the same time, they all served a completely different purpose. But when it comes to discussions at international level, all these things need to be taken into account. And I know I've spoken too much. I've given you a mouthful, but I think all those are considerations that need to be thought about when you are assessing appropriate instruments. What instruments are in the countries of mass atrocities, and how best can these instruments, if they've been working, even if they are alien to the people that make the decisions, but how can they be used? The traditional instruments, the other instruments that people are not familiar with, let us not completely dismiss them, but pick what is best in there and see the usefulness of them, not dismiss them just because they sound completely anathema to what you believe in as justice. But I think, honestly, we ought to think about instruments in the context of each country and make appropriate decisions. You cannot tailor one size to fit all for all situations. Basically, that's what I believe. Thank you.
Yeah, that was kind of a powerful testimony, I would say. And I was seeing Phil and James nodding in agreement. James, do you want to come second?
Thank you so much. Thank you so much, Alphonse. And yes, I would like to share my thoughts on that one. And you saw me nodding because I think Ms. Kabasinga made something, made a statement which is very important in terms of relating to the historical development of these instruments. That after Nuremberg, there was kind of nothing between. So nobody knew what kind of instrument should we have, in what situation, and would you point it not from what assume that there is institutional knowledge or memory of what works and what will not work in different situations, because what happened during Second World War is not what happened in Rwanda or what happened in former Yugoslavia and so forth. So that I think that. So I think in a specific context, but in addition to that, whether it's international or at national level, I think to reflect upon. The first one is that those instruments, I think, first of all, they have to adhere to certain principles. I think they have to have a certain level of fidelity to the rules and procedures that establish them. I think whether it's national or at global level, I think I'll get back to that and explain. But also the other way of assessing appropriate instruments is that deter crimes from being committed. I think I would like to dwell on those 2 points. So on the first one about adherence to institutional rules and procedures, I'm making a big assumption here that those rules and procedures are not biased or are not reflecting any power. Sorry about that. Any power
Did you
structure
just
or
throw
dynamics.
your phone away, James?
Because I think we see that a lot. Say again.
I hope
it was.
He's got government ministers. He's got government ministers calling him, saying, "James, it's a Friday night. What advice have you got?" You know, he can't say no.
Yeah, so nice, guys. No, it was really stressing me out that it was kept on ringing. But no, I threw it away. I think it's not going to ring again. I gave it to someone. Thanks so much, and I'm sorry about that. My apologies. It's an oversight on my part. No, I was saying, you know, it's domestic or at global level. I think what's important is that such instruments have to show some level of fidelity to the rules and procedures that establish them. And the assumption I'm making here is that those rules and procedures are made in such a way that they reflect the societal values and the societal norms that needs to be protected. Right. So it's easier when it comes to domestic jurisdictions or domestic level. However, it becomes complicated when it comes to global at global level, global justice, where you find out because of power and politics, instruments reflect or are biased towards dominant, powerful states. That's the main issue there, and that's one of the ways. But let me go a little bit further and say, yeah, let me go to the. Let me give a case study of the International Criminal Court, which I think I've spent some time trying to study how it works. And you see that the Rome Statute, which established the International Criminal Court, does have clear rules pertaining to selection of cases or no of situations, and within those situations of selection of cases. That's a set rule and a procedure. We also have a case of admissibility. So the law is very clear on what should be done. But when it comes to the application by the instrument, by the office of the prosecutor and so forth, you see that that's where the challenges are. And there's been so far a tendency to have this common law approach to legal affairs, where the judge is prescribed and being showing a little fidelity, so that I can also let others. I have an example. I don't know. I don't think a lot of attention has been put into the referral by Comoros of the situation in its territory, which was ships. These are boats or ship, huge ship, humanitarian ship that were trying to take humanitarian aid to Gaza, and they came under attack from Israel. And then the issue was referred because under international law, a flag-bearing ship assumes the territory of where the flag is from. Like, so in this case, this ship were flying Comoros flag, and then which means the ship was a territory of Comoros, which is a state part to the International Criminal Court. So they referred the case to the International Criminal Court. Then the office of the prosecutor came to them and said, actually, because during the confrontation between the these aid flotilla to Gaza, about 9 people died and a lot of them were injured. So Comoros thought it was a case for the ICC to intervene. But the office of the prosecutor, did a preliminary examination and said, actually, no, the case of gravity, what happened does not meet the threshold of gravity that we want. So we are not going to continue with any investigations. Okay, fair enough. But of course, Comoros appealed, and then the pretrial chambers said, I think the office of the prosecutor simplified everything. But okay, let's put that one aside, and then let's go to Mali and the Timbuktu, right? Of course, it's a historical, the destruction of Timbuktu by the Mali referred the situation, the office of the prosecutor took up the case, it was a conviction. Of course, a historical side, I'm not undermining, but comparing historical sides and
James, I'm afraid your bandwidth is low, but I think we got your point. And here, Phil, I think the point James was trying to make is that the understanding of seriousness of crimes might be different. Here on one side, there is the destruction of cultural heritage infrastructure, and there is the killing of 9 people. So people might actually have a different understanding on whether and when international criminal justice should intervene or not intervene. But I give the floor to you, Phil, to expand from there and then make your own intervention.
Yeah,
thank you, Jim.
Thanks, Alphonse. I think this is such a crucial question of how we think about the appropriateness of justice processes. And I was particularly struck by a word that Florida used, which was that states are often scrambling to work out what the best justice approach is. And I think that's such an apt word, because states coming out of mass conflict, whether it's genocide, war crimes, crimes against humanity, or long periods of repression, are always in a non-ideal situation when they're trying to decide what justice should look like. So this question of what is appropriate is being determined in some of the worst possible circumstances. The state has sometimes been destroyed, large numbers of people have been killed, lots of people have been displaced, things are in absolute tumult, and these very tough decisions about justice are having to be made in that kind of context. So I think what we have to recognize is the pressure and the very complicated circumstances in which these justice determinations are often being made. And that's why I think that word scrambling is apt. Now, why does that matter? It matters because people are trying to decide appropriateness with the weight of the world on their shoulders and often very few instruments at their disposal. Now, what tends to happen, I think, in that scrambling situation is then international actors try to impose their will. In this political vacuum, at these moments of vulnerability, many states then get these international instruments imposed upon them, often because they're not in a position to push back against international pressure. And of course, I'm thinking here of countries in Central Africa and Eastern Africa, where Florida and you, Alphonse, and James are from, and where I also do my research. These were states that were having to make these justice decisions in the aftermath of genocide, in the aftermath of post-election violence. And suddenly the donors, international lawyers, international human rights groups were there telling these states, this is how you have to do justice according to our international templates, without really thinking about the question of appropriateness. And the states in this region were under a significant pressure to take on those international prescriptions because they were in this very vulnerable position. I think what this gets us to then is something that James and Florida have already talked about, which is the question of appropriateness has to be contextual. What is appropriate in the very particular society, the very particular communities where crimes were committed and where people are trying to recover? And if we're not taking those perspectives on board, if we're not taking localized understandings of justice into our discussion of appropriateness, then we're barking up the wrong tree. We're going to end up with models of justice that bear no resemblance to what local people think justice should look like. And that's a very dangerous thing. The imposition of decontextualized justice, I think, is incredibly damaging to the societies in question. So context matters. We have to see appropriateness in a contextual way. But what I would also say is what the contextual understanding of justice looks like is itself complicated, because societies are divided. Not all people agree. I mean, I'm thinking here particularly of the Rwandan case, where I remember when gacaca was instituted in Rwanda in 2002, one of the most vociferous communities opposing gacaca were Rwandan lawyers, legal practitioners within Rwandan society who couldn't believe that the job of prosecuting genocide cases was going to be given over to these lay judges elected by their local communities who weren't professional judges and lawyers. So what that showed was that even within Rwanda, there was huge disagreement over what justice should be and what instrument was ultimately appropriate. So context is important, but context doesn't immediately give us the appropriate answer. There's a process that has to be gone through, a society debating within itself, different viewpoints coming together, and hopefully some kind of consensus can come out of that. So it's a messy process. It's very, very difficult. There isn't a ready-made contextual solution that's just sitting there on the shelf, ready to be adopted. There has to be a dialogue. There has to be a debate first. The final thing I'll say is, I think when we think about the appropriateness of justice instruments, we also have to be really careful about expecting that one single instrument is going to do the job. That the question of appropriateness almost inevitably leads us down a pathway of thinking about multiple instruments, but also multiple processes over time. It's unlikely that a single court or a single justice intervention is going to deal with the legacies of something as complex as genocide or crimes against humanity. It's probably going to be a wide-scale, perhaps society-wide process of political transformation, identity change, very subtle shifts in societal relations. No single instrument is ever going to do that. Particular instruments may play a role, but it's likely to be a combination of different instruments and much longer political processes. So we have to be careful, I think, about this language of instruments, because it can make us think that there's some knockout blow that can be made with one particular institution or one particular intervention. So this is messy. This stuff is really messy. This is a really complex question, and it's good, I think, Alphonse, that you've asked us this up front, because it gets a sense of the messiness out on the table right from the outset.
So I want to jump in here.
Yes, go for it. And maybe you continue with the question I wanted to ask. Given the messiness, as Phil has just mentioned, is it possible to know when international law, for example, is an appropriate instrument, or when is not?
Okay. So when Phil mentioned the messiness of it and how one instrument cannot fix a situation like that, I think it comes home with the realization that, listen, if there was one way of fixing it, I don't even think we would have had the conflict to begin with. It's a whole mess. It means by the time you have mass atrocities, it means society is completely broken. There's something really huge going on. So in essence, basically, when you're trying to fix something that has been broken or brewing for so many years, you really need a plethora of all kinds of instruments to try and fix it. And also on the issue which you spoke about how legal practitioners in Rwanda were up in arms against Gacaca. I think in reality, when you think about it, if you've been trained in the Western world and the Western view of looking at things, you will exactly have that same knee-jerk reaction. But think about a situation where you have, 1 million people dead, so many people, hundreds of thousands of people in jail for crimes, a broken judicial system, suspects, the key suspects are fled all over the world. There is no way in that situation that you are going to have one stroke of a pen of an instrument and you deal with the whole situation. You have people, in West Africa who are key suspects. You have them in Southern Africa that are key suspects. You have hundreds of them in Rwanda. You have some of them in the neighboring countries in refugee camps. So if you want to deal with this, you will need all kinds of answers, for example, to deal with it. On the question that you've posed, Alphonse, when is international law the appropriate instrument and when is it not? Quite frankly, I do not see how in a situation it would be easy to not see the advantage of having international justice somehow in one way, form or another. However, if I'm thinking about a situation where you have a country that is, I think it's easier to answer when is it not appropriate. Maybe if you have a country that is willing and able to take on this task, and they have a justice system that is working, they have independent judicial system and all of that. But do you have a country like that having mass atrocities? That's a question that maybe we need to think about. But I'll tell you what, when you have conflict that results in mass atrocities, you often need somehow a third party, a foreign entity to come and try and somehow, through some different measures to try and make sure things are going well. Because normally when you have a situation of mass atrocities, literally everything breaks down. And so I'll give you an example, like the one I was talking about of Rwanda. You have all these people that have fled, you have a system that is broken, and in order for justice, in order for the country to move on, you'll obviously need to have justice. And what form does that take? In 1994, after what had happened in Rwanda, would Rwanda, for example, have been able to track all these suspects all over the world and have them extradited and bring them to Rwanda and actually put them through a process of justice, domestic justice? That would have been a tall order. And I think that's where, that's the situation where you need an international instrument that we're talking about. You have so many different considerations when you talk about all of that. And when you're considering appropriateness, not just of international instruments, but of others, you must take into consideration what we've been talking about, tailor-making for each context. And that means you have to consider what are the things that you aim for with that instrument. Is it reconciliation? Is this just pure justice? Are you looking at considerations of national security? Is the system in that country fit for purpose? Do you have trained lawyers? Do you have trained prosecutors? Do you have independent judges? What kind of thing are you looking for? Reconciliation, participation of victims in the justice system. So all of those things have to be considered. And I think where you talk about, for example, national security, where you have people that are so powerful in the conflict. Let's take, for example, Sierra Leone, where you had all these rebels that were so powerful that were doing all kinds of mass atrocities. Would Sierra Leone, after the conflict, have been able to try these people and take their influence away at the same time? So you bring in an international instrument, maybe to assist with the local instrument, and then you make sure that once they are tried and convicted, they are taken out of that context and imprisoned far away from the context in order to allow and give space for the country to move on. So there are all kinds of considerations that I think we've already even spoken about it. Take, for example, the former Yugoslavia. You have different countries that were formed part of the former Yugoslavia. What exactly would you have done if you were to take an instrument that was purely domestic? Would you have told the Bosnians to try the Serbs? Would you have told the Serbs to try the Bosnians? How exactly would you have said? Would you have told each one of them, try your own people in your own countries? And these are national heroes to these people. So there you absolutely need an instrument that would come in that is not domestic to assist. And I think, those are some of the considerations that should go in. And I think for each situation, you have to assess it differently. Thank you.
I can see James is still reflecting. I go first to Phil to react on Florida's response?
I think my starting point here, Alphonse, is that the last 25 years of international criminal law have been incredibly disappointing, incredibly underwhelming. I think if we go back to the great hopes and dreams for the ad hoc tribunals in the 1990s, the International Criminal Court at the beginning of the 2000s, and we listen to what was promised and then what has been delivered, there's a gulf between those two things. So I think the starting point to this conversation has to be that in many ways that this is a form of justice that is in crisis. And I'm in some respects even surprised that in 2021, we take it as seriously as we do. Whether it was the ad hocs or the ICC, these were institutions that prosecuted a handful of cases of senior suspects, and in many cases couldn't even get them in the dock. That did very little, I think, for the reconciliation of local populations, which at least in the Rwandan case was something that the UN tribunal promised that it would address, that it would assist. I think it did very little at that level. If we look at the ICC, this is an institution that has only managed to get about 20% of its caseload in the dock in the last 20 years. More ICC cases have collapsed before trial than have actually resulted in suspects being prosecuted. And international justice, in many respects, has ridden roughshod over domestic institutions. It has often dealt with cases that could have been dealt with through domestic courts, either in the way that those domestic courts already existed, or had there been serious investment in a domestic reform process, would have enabled domestic courts to deal with those same cases. But we never saw the chance because international justice was in there before anyone could take a breath. And so I think the starting point here has to be an honest reflection on just how disappointing the international justice enterprise has been in the last 20 years. And also a reflection on what opportunity was missed, rather than spending 20 years hoping that one day something like the ICC would become an effective institution. What could have been achieved had there been serious investment in domestic courts all over Africa? I think we've missed a drastic opportunity there. So if we're thinking about the appropriateness of international law, I think the starting point has to be that more often than not, we've imposed it where it wasn't appropriate. This is an instrument that has been used all too readily without very much consideration of whether, in fact, this is a very useful instrument. The question that I always come back to is, what actually is international justice good at? And what can it do that domestic institutions can't do? And more often than not, what I come back to is a realization that domestic courts typically can do the job of international justice if the investment is there, if the dedication is there. And the virtue of investing in domestic justice is that these are the courts that will ultimately be there in perpetuity. International justice will come and go as it pleases. It's an incredibly fickle enterprise. Look how quickly the ICC dropped cases in Kenya when the going got tough. Look how distracted they got from northern Uganda. Look how quickly the ICC abandoned a situation like Mali and then suddenly had to re-engage with Mali. International justice will come and go. Domestic courts are there forever. And so I think that we've got the whole discussion wrong. I think the discussion should be, what do we need to do over the long term to build robust domestic courts? And I think that we have become too preoccupied with an international model that time and again has proven wanting when it comes to dealing with serious atrocities.
James, I kind of knew your response for this question, but after the pragmatic response from Florida and the pessimistic one from Phil, I still have to ask this question.
We've left you the whole middle terrain.
Yeah, exactly.
I didn't know you were that disappointed, Phil.
I know, Florida. Despite having fantastic you on the I thought that you could rescue it. But, you know,
James,
this was
let me
too big a task even for you, Florida.
let me ask you to combine these two interventions with this question that I'm going to ask. Because, you know, international institutions and norms are created by state actors. And those actors operate in and reflect the existing global power imbalances? Is global justice, in particular criminal justice, capable of treating all actors equally and fairly when global politics, economics, and other systems are not fairly distributed? For purposes of illustration, we can take a reference to the current distribution of COVID-19 vaccine, where some countries have been giving booster jabs to their citizens when some other citizens of the world had not even been given the first dose. And this is in fact not because these countries, for example, in Africa, were unable to pay for the vaccine. So I guess the question I have for you, James, is can global justice be distributed fairly when other things are not? In other words, can global justice transcend international politics and power imbalances? Very broad question, but I know
Okay.
you
Wow.
give it justice.
Yeah, I know. Let me try. Can you hear me?
Yes, we can hear you, James.
Okay. To begin with, I'm not a big fan of this hegemonic global justice system that we have. I'm not a big fan of it. But at the same time, I do not want to romanticize domestic justice system, right? So it's neither to say global justice system is hegemonic and it does not respond to our reality, and then we have the domestic justice system as a response. I don't think it's as clear-cut as that, because we know in across a lot of countries, jurisdictions, that domestic justice system are not perfect either. Even within the context of the International Criminal Court, we see that at national level, at state level, there's a tendency to try to use to weaponize international criminal justice to make for it to target enemies of the state. So you asked me how to reconcile the two. I think the two can be reconciled only by having genuine dialogue, and starting from what Florida said, that it's not about imposition of what worked elsewhere should work here.
If I can intervene,
to say domestic.
Is it possible to have a genuine?
We'll have to have parameters of what we are comfortable with. Genuinely, we have to agree on what we think we can work with, and that can only be can be found by having genuine discussion. Because I remember when Phil started, I like that he referred to the to the reaction of the legal fraternity in Rwanda with reference to Gacaca courts. But I think I would actually go a little bit earlier and refer to the debates about death penalty. But you remember, Rwanda was voted against the establishment of the ICTR because of death penalty issue. And if I do not know, I do not know, but if you ask people now, maybe in Rwanda, maybe it would be interesting to see whether they would think that having death penalty as part of the sentencing was going to be a good decision or not. I do not know. This just to
James is frozen again. Can I jump in?
Yeah, yes, please. Go ahead.
Then I want to jump in too.
He's
Is he back?
Yes,
he's back.
Complete your intervention, James. Then
he's gone again.
Always about to make his killer point, and then the connection cuts out. He's always on the cusp, where he's about to lead us to the promised land, and then he gets diverted.
It seems it's breaking, so I'm not following. Am I still continue with my submissions, or
go ahead, James? You had disappeared a little bit.
Okay, so I'd said I think we need to have a dialogue between global justice system and domestic justice system, a genuine one, to come up with what is what works for a particular situation. And remember, I started by saying I'm not a big fan of global. This is what I call it to be hegemonic global justice system that is dominated by the values and interests of the powerful states. And I'm not a big fan of that. Why? Because it kind of ignores the realities, the context, the local context, and kind of patronize them and consider them to be like they cannot contribute anything, yet they have a lot to contribute, and they've the experience and in my view, localization of justice informed by global standards, right? Not only localization, because I experienced it in Zimbabwe. I'm from Zimbabwe. I experienced it in Zimbabwe, so I know it the best. No, I think it's localized because there are certain aspects about it being local.
He's gone again, but I think
which could be helped by of death penalty as part of the. So you've seen how. Okay, why am I going?
Yeah, no, that's fine, James.
Your video is playing games with you, James.
I think we got your point clearly, and I want to give the floor to Florida. Let me give the floor to Florida because she really wanted to react on your comment.
Okay.
I actually wanted to react on Phil's comment. I think in James's other life, he's
okay. Go ahead, Florida. Go ahead.
He's trying to mediate this fight.
Good luck. Good luck. Oh, now it's Florida who's frozen. She was also about to lead us to the promised land of justice. It's like Zoom is interfering every time the genius moment comes.
Did I get cut off as well?
You did get cut off, but you're back.
Oh gosh. Oh, okay.
No, you're clear.
So okay. So I meant to ask Phil. You're like on the extreme end of pessimism. But I'll tell you this: there were failings, but there were some really good things that came out of it. And I'll just tell you about the ICTR. I am so clear on its failings, but I'm so clear as well on its advantages. Think about a situation that happened in Rwanda. You have right after the genocide, everybody's going to the neighboring countries with all their military apparatus and their government apparatus, and they're right by the border, like 1 kilometer, 2 kilometers from the border. And they're posing a serious security situation, to this country. And then you have the entire world, international community saying we have to do something, we have to do something. And then, they start spreading out because now they're freaking out, they're going to get arrested. And then they're tracked through Chapter 7 of the UN Convention. They're tracked down and arrested and tried. And this country is given a chance to have some sort of stability. And then you have a record of what happened in this country. You have people testifying, you have, members of the NGO community, you have experts testifying, you have people that were on the ground, you have victims, and everything is recorded and, transcribed. That is something that would not have been done domestically. Now, the things that Phil, you're saying that, they could have, the international community could have focused more on strengthening the domestic courts. And these things that you're talking about that interfere, like in the Mali situation, in the Kenyan situation, that is, it's politics and country interests that are frustrating international criminal law. But is it the failing of international criminal law systems, or people fundamentally frustrating them for certain interests? And also, if you are to strengthen the domestic context, how exactly do you do that without taking into account that the same frustrations and interests are going to frustrate the same domestic, the politics and all of that? If you have witnesses that were supposed to be testifying at the ICC being murdered, how are they not going to be murdered in a context of a domestic trial? So, I honestly think, to be pragmatic, and I think I took over James's role. I mediated myself with Phil somehow, and but I think we ought to see, you know, the good stuff.
I think my point is that the analysis for domestic justice is always harsher than the analysis is for international justice. I think we let international justice off the hook. You know, people always say, oh, domestic justice is politicized, it's manipulated by domestic elites, it's vulnerable to corruption. I agree. Without a doubt, it is. We shouldn't romanticize domestic justice. But what I would say is all of that also applies to the international level. But the international level has been getting, but the international level has been getting away with that for 30 years. That's the critique that is the critique that is more commonly applied to the domestic sphere. And yet international justice has always been able to maintain this myth that it is apolitical, above the political fray, it's more technically adept, it's impartial, it's even-handed. That's the default positions. I mean, certainly in academic circles. I mean, maybe practitioners like Florida know this better because they're inside the beast.
Let me
but I
tell
think
you
what I'm
something
asking,
about
I think what I'm getting at is that all of these institutions are open to the same kind of manipulation. There's a sense of equality there. There is not an inherent superiority to the international level in terms of being insulated. So if that's the case, if there is an equality there, why aren't we pushing the discussion more towards the domestic? Aren't we saying, given that the international does not have any inherent advantage in terms of being less politicized, why are we not putting our time and energy into the reform of the domestic courts? I mean, I also come back to the Rwandan experience. In my view, the institution that played the most fundamental role in terms of justice and reconciliation in Rwanda after the genocide against the Tutsi wasn't the ICTR, it was Gacaca. The system that matters the most, I think, on the hills for genocide survivors, for the reintegration of perpetrators back into their home communities, has got nothing to do with international justice. It's the domestic court system, and it's Gacaca. Now, if that's true, if it's true that in 2021, the system that has had the most profound effect, the most positive effect on the everyday lives of everyday Rwandans is a village-based system, why did we spend all of these years going down a pathway of international justice? Did we not miss an opportunity in the early years? Should there not have been more thinking and more investment in a completely different model of justice than the one we went down? Now, Florida, your point is, okay, but a domestic system would never have been able to bring all of these suspects home. There would never have been this international effort to bring the masterminds of the genocide back. And I would say, is that true? Because at the end of the day, that wasn't so much about the ICTR as an institution. That was about Interpol, international policing, international cooperation. Isn't the argument then we need that kind of international cooperation to bring those suspects back to a domestic system? Because people's ability to see these trials play out in front of their own eyes in the same communities where crimes were carried out is the kind of thing that has lasting effects. So we need the transfer of suspects bit. I'm just not convinced that we need the international tribunal bit at the end of what you're arguing for.
And that separates us, the practitioner and the academic.
Which is why they put us on the same Friday night panel.
May I just come in?
James, come in, please.
James does both. He's like a hybrid of me and Florida.
To be honest, one thing that one aspect which is very important, which we should learn, I think, from Rwanda, in how it addressed and provided an alternative, is that it did not just criticize what was there, the ICTR, but it provided a domestic solution. That one, I think we should respect that and acknowledge that. That's unique, and I hope we could emulate that in many other countries. But the challenge is, in other countries outside Rwanda, is that the Rwandan situation after 1994 genocide against the Tutsi is that we had a complete change of power structure, right? Which made a lot of things possible, right? So it cannot, we should not it's unique, and we should support that and learn a lot from that. But if we go to Darfur, right, with President Omar Bashir in power, to think that the domestic justice system was going to be able to work out something in terms to provide justice to the people of Darfur, I think we will be stretching it a little bit so much. So what I'm trying to say is that, like I said, and I insist that this hegemonic global justice system is not the ideal situation. It's not, and we need to work to change it. But the best way to change it is to go back to the domestics, like what Rwanda did, to come up with its own contextualized, localized justice mechanisms and implement it and give, as an example, to say that, okay, we have done this, we have solved our problem. The challenge is only Rwanda so far, which we can give as an example. But we have a lot of atrocities being committed across the world, and we are not seeing. Maybe Colombia, I've seen that Colombia seems to be doing something, but majority of countries, and this justifies the emergence of international justice system, flawed as it is because the domestic people who perpetrated these atrocities, right, are the ones who control justice system, and they are unlikely going to take themselves to court. That's why we had the international justice system. So what is the solution? Like I said, is to work and strengthen, and I think that's what Phil also said, to strengthen and have the political will within the domestic system to come up with the solutions so that we close intervention from these flawed hegemonic global justice system. Thank you. I just want to add that.
On that, Phil, I want to bring in with that James's suggestion that we go back to domestic system. And I already saw you wanted to intervene, but I want to ask so that you take it together. What, with your experience, what other extra legal avenues there is that would help to pursue justice?
Yeah, thanks, Alphonse. No, I think that's a perfect segue from what James was talking about, because I think there's become quite a lot of lazy thinking around justice in the last 20 years. We automatically think that the answer is courtrooms and prisons. And I think that the history of especially international justice over the last 20 years should really give us pause for thought about whether this should be the dominant framework. I mean, is this the main way that we should be thinking about justice? And again, I come back to the example of Gacaca, which of course was itself a legal process. This was not an extra legal process. This was a legal process. But I think what it showed was that a country like Rwanda could think creatively about what justice should look like in its particular context. Now, the Rwandan government chose to institute Gacaca against all international prescriptions. The donors, the human rights groups, were all saying, don't do it. You can't prosecute genocide cases through these everyday courts with untrained judges. Rwanda basically said, look, we think that this is what we need. We need to do justice in a way that fits our circumstances. We have hundreds of thousands of suspects. We can't amnesty them and send them back to the hills. That's going to lead to a bloodbath. We've already detained 130,000 genocide suspects. We've got to find a system that deals with all of these different demands. And so Gacaca comes out of that very, very particular practical context. I think what that shows is that a country like Rwanda was incredibly bold. It was incredibly creative, and it ignored a huge amount of international noise. Now, I'm not saying that all societies should do something like Gacaca, because that would be another form of imposition. But I think what I am saying is we need to take the inspiration from a country like Rwanda that said, we're going to do this on our own terms. Now, an anecdote that I'll share in this regard is that about 6 or 7 years ago, after my book on Gacaca came out, I got invited to go to Colombia. Now, I'd never been to Latin America in my life. I was invited by the Colombian government to present findings from my research into Gacaca. At that time, Colombia was going through the Havana peace process between the Colombian government and the FARC. there were 6 different ministries in the Colombian state that all had a transitional justice unit. So I did the rounds of all of these units presenting my findings. And every time I presented on Gacaca, I started by saying the same thing. I have no idea whether anything about Gacaca is relevant in your context. I don't know the first thing about Colombia. So I'm going to talk about Gacaca and then you tell me whether any of this is applicable or not. The one thing that every single Colombian government unit latched onto in relation to Gacaca was that you could be creative about sentencing. So you could punish perpetrators, but then when it got to the sentencing stage, you didn't necessarily have to imprison people. You could use community service, you could use a whole range of other tools. Now, what's interesting, I think, and I'm not claiming credit for this because lots of other people were giving the Colombians similar advice. If you look at what's come out of the Colombian peace process, is a very new model of justice. It's a model that says we need to prosecute and punish perpetrators, but when it comes to sentencing, we're going to do this differently from how this has usually been done. And they're playing with this idea of deprivation of liberty. So maybe you punish someone not by sending them to prison, but you constrain their liberty in various ways. And that was the kind of thing that Colombians had to do because the peace process was under pressure. If there had been too heavy punishment, the FARC would have walked away from the talks. But also, if there had been an amnesty or something that was considered too lenient, the donors and the ICC were breathing down Colombia's neck. So they were under pressure and they had to find something creative. And Gacaca was inspirational, I think, to the Colombians. It said, think outside the box. It's okay to come up with a model of justice that maybe the international community isn't necessarily going to agree with, but it is going to be applicable in your case. So I think the point I'm getting at is that we have been too narrow. We have been too constrained in our thinking about what justice is supposed to look like. And there's an infinite array of other ways to think about this. We have become homogenized. We have a one-size-fits-all universal notion of international criminal justice that has dominated all of these debates. And I think it has distracted us from thinking much more creatively and systematically about what's needed in particular cases. Now, another anecdote that I'll share that I think fleshes this point out is I spent a lot of time in Juba, in South Sudan and in northern Uganda at the time of the Ugandan peace talks. And the Ugandans were grappling with a similar set of issues to what the Colombians were. Peace process is underway, ICC's breathing down our neck. We've got to find a justice approach that keeps all these different parties happy. One of the things that a UN mediator at the Juba talk said to me was, what is amazing now in the era of the International Criminal Court is we could never, ever have a South African style truth commission that gave an amnesty to senior perpetrators of serious crimes. The kind of model that was available to states in the 1990s is no longer available. If you try to institute a TRC like that today, the ICC, donors, international human rights groups immediately come down and say, there has to be criminal justice for senior suspects. So we are now looking at a global situation where the options are considered to be limited, where unless it's criminal law for top perpetrators, it can be nothing else. And I think that that's a really desperate situation. We have taken options off the table, whereas in fact, what we should be doing is putting options back on the table. States dealing with massive atrocities need flexibility in its most maximum form. They need all the possibilities available to them to determine what is available. The final thing I'll say, Alphonse, because you frame the question as what extra legal avenues exist for the pursuit of justice. And I've talked about Gacaca, I've talked about TRCs, but I think we've got to come back to something actually that James Florida and I were talking about right at the beginning of this discussion, which is, what about the transformation of entire societies that is needed after something like genocide or after massive atrocities? Single instruments, single institutions are not going to achieve that. So shouldn't we, rather than thinking about legal institutions, also be thinking about political transformation? What is needed to change political systems? What is needed to deal with conflictual identities? That's not going to be done through a court process. That's going to be done through a whole range of other mechanisms and probably processes over a very lengthy period. We need to be talking about that. What about socio-economic transformation? There's a huge amount of discussion in transitional justice circles at the moment about transformative justice, that the idea that many conflicts around the world are driven by socioeconomic inequalities, deprivation. Our response to conflict, therefore, has to tackle socioeconomic inequality. It's about redistribution. It's about land. It's about welfare systems. That's a form of justice. Redressing socioeconomic imbalance is a crucial aspect of justice. Court processes are never going to be able to tackle that particular domain. And I think a lot of our conversation now needs to go down the line of political transformation, identity change, and also socioeconomic transformation.
I would be at this moment moving to the comments or questions from the audience, but so far I can see only compliments on the way the conversation is going. And another question was I would say was answered. It was about how if politics affects international justice, it also affects domestic justice. And I think we have already discussed that question. But the conversation has made me think of a discussion we had in Arusha in 2006, I think, when we were discussing about the legacy of ICTR. And myself with the other people from Rwanda, we were saying that ICTR archives should be coming to Rwanda. And those from the United Republic of Tanzania were saying, you know, we have hosted the tribunal, we can also host the archives. And the Hague was saying, we are the, you know, we are the capital of international justice. So archives should come to the Hague. And this made me, because I remember I stood up and I screamed out of my heart and I said, but Rwanda is also part of the international community. So the question I think I have for all of you is, to whom do we do justice? And maybe I start with you, Phil, and then I go Florida and James.
Look, I think for too long, the answer to that question has been this nebulous international community. I think justice is often done to reflect an international mentality, that it's about fulfilling the needs and desires of donors, of international courts, international policymakers. And we have to revert this question to the domestic sphere. We have to say, how does justice make sense to people in that particular place at that particular time? And as I've said, that itself is not an easy question to answer, because local spaces themselves are always contested. There will never be a homogeneous Serb or Cambodian or Rwandan or Ugandan view on what justice means. But we have to engage in that very messy local process, I think, to determine what justice should ultimately look like. And I mean, another example that I'll always come back to is something that struck me through all the years that I was researching the Gacaca courts was people at the local level in Rwanda were always conscious of what was happening at the ICTR. You know, they were hearing about it on the radio. They knew what was happening in Arusha. And I'll never forget the comment that one particular elderly woman in northern Rwanda made to me in 2009 or 2010, I think it was. And she said, you know, those suspects that are prosecuted at the ICTR, that's not real justice, because they avoid us by being there, as opposed to suspects who have to come to Gacaca and look us in the eye and have that direct confrontation and have to engage in a dialogue with genocide survivors. She said they avoid all of that by being there in Arusha. And I thought that was such a powerful statement, because what she was ultimately saying was, within our context, justice means being face-to-face. It means dialogue. It means not being able to squirm out of the conversation. And she thought that the suspects being prosecuted in Arusha was squirming out of the conversation because it was distant, it was detached. And that's always stayed with me as a real statement of that particular idea of contextual justice, what it meant in that village that had suffered the genocide and now people were going through Gacaca. And it was the basis of a criticism of international justice, that it wasn't doing the kind of thing that was considered valuable within Gacaca itself. So that I think has to be our starting point when we answer your question, Alphonse, about, you know, to whom should justice be directed. I think it has to be back to those communities that most directly suffered those crimes. And if that's not our framework, then we're probably doing something very detached, very disembodied, that ultimately probably won't have the kind of impact that we hope it will.
James, I can see Florida video is off. Do you want to come first, Florida, or I go to James first?
You can go to James first, please.
James.
Thank you, Alphonse. Actually, you know, before if you allow me, before I respond to this direct question, there is something which I think Phil said, which is very interesting and very important, perhaps overlooked in our discussions pertaining to international criminal justice, is how much the civil and political rights dominate our narrative, and not the socio and economic rights. That's a very, when he mentioned that, we should not look at justice in terms of individual rights and sending people to court and so forth, but it could be distributive. It could be about people accessing resources. And it seems that kind of discussion is not very visible if it's happening at all. And if you allow me again to stretch it to the question of the COVID-19, right? It's actually speaks to that division in our discussion when it comes to distribution of resources and debates about what we advocate for and not. People, we talk more about civil and political rights, but not right to health. And now we can see we are being exposed when it comes to vaccines and so forth, that right to health, we don't consider it to be very important compared to other rights, civil and political rights. I just wanted to highlight that and to pick on what Phil had said, and it's also clear in the justice system. Okay, when it comes to who are the beneficiaries of justice, in my view, are the victims. There's no question about that. The idea of trying to make an international community as a victim, I think, is a little bit far-fetched, and I don't think it's very convincing. So when we are talking about justice in the context of Rwanda, we are talking about the Rwandan victims of genocide. There's no, to talk about international community, I think it goes to this fact that came by when we said after the end of Cold War, there's one community, international community, which you and me, and I think most of the panelists here agree that there's nothing like that. I think you can see again in the context of COVID that there is no international community. You are on your own, right? So the victims of the beneficiaries of the of justice system in Rwanda are supposed to be the Rwandan population. And in addition to that, there is a big aspect of memory, which we should not forget. I think it's important that all the archives, all the information, the trials and evidence should be stored where it belongs in Rwanda, so that the people have the memory of what happened to them. And you can see it, I think, you look at for instance, the Jewish Holocaust and the memorization that they invest a lot in that. Why should that be, why should Rwanda be denied that? Not only Rwanda, but other countries as well that have gone through this sad episodes in their lifetime. So that's how I would say, let's not be fooled by this idea of having international community. I think it's not there. I think COVID has exposed that. The victims are supposed to be the beneficiaries of justice. And there is an issue of memory. And memory is very important in the life of any community. What I find always interesting about when we discuss international justice system, it's like this is my last point, we have kind of moved away from historical injustice that Africa went through, right? To start off from post-colonial Africa. And that's a big disservice to Africa, to Africa and its memory. because we are reducing history of Africa to be post-colonial Africa, and we are now talking about atrocities committed here. Yet we have a lot of atrocities committed before that. And I'm just trying to emphasize the issue of memory, and there is a lot of, at the moment, discussion about artifacts, memory, memorization, and returning things that are in artifacts, African artifacts that are in museums in Europe, to come back to Africa, because it's part of our memory. It helps us to remember ourselves. Thank you so much. That's all I want to say.
To you, Florida.
So there's something that I really, really want to emphasize on this. And I think James touched on it. Whose property is it in reality? These documents belong to Rwanda. They really, really do. In the aftermath of what happened here, when the UN swooped in and investigations began, they actually took documents that belong to Rwanda. Where should they be? They should be in this country. And it is true that we all somehow pretend that when you commit international crimes, you've actually committed, it's theory, you've committed it against the entire world, it's theory. Who really, really cares about what happened? And for whom does it impact? Like the lives, whose lives that does the work, for example, of the ICTR impact? It's the lives of Rwandans. What James said about memory, who in the years and decades to come really will want to know what happened. When the international community wants to do something after mass atrocities, they really scramble and put ad hoc tribunals and all of that. But once that is done, they will move on. It's not their issue. So if you host this archive in Arusha, you will have it collecting dust. Nobody is going to come from here to go look at it. It's going to be some bizarre thing out there that maybe one or two Rwandans who managed to go see it, or somebody who has gone on a safari in Serengeti and just passes by for a few minutes to have a look. But really, the archive, I have no doubt, should be in Rwanda, because the documents belong to this country, and because generations of Rwandans, will have to look at its work to learn lessons from it. Are we kidding ourselves that, after the 1994 genocide, this country's problems that resulted in the genocide are done? Of course not. We have to learn from our history and what happened, and get lessons from there that we can use for us never to have this again. And if you have the archives in Arusha, how does that help? How does that help? And to me, quite frankly, I think this is a continuous abuse in having those archives away from Rwanda. The United Nations and the international community gave a lot of money for that archive to be built. I think Rwanda being part of the international community, the United Nations as well, they should have just built the archive in this country, really. Aside from the fact that the location of the tribunal having been in Tanzania, in Arusha, for victims and witnesses having been deprived, seeing justice being done the way they saw it during the Kachacha process. On top of that, then the archive stays, I think it's a continuation of a perpetration of an injustice, to be quite honest. That's how I feel. And I hope someday it gets redressed sooner rather than later.
Yeah,
Alphonse, can I come in on the back of what Florida said? Because
please.
I agree with everything she said, and I agree with everything that James said there. James is also a remarkable peacemaker. I think he's always, James, you've always had a skill for finding the common ground on these things. But the point that I would make on the issue of the ICTR archives is, what does it say about the mentality of the UN and also the mentality of the tribunal that there's even a debate about where this archive should be. I mean, I think that the UN's possessiveness over that archive tells us a lot about its philosophy, that there's a sense of superiority towards Rwanda, that there's a sense of you can't trust Rwandans to look after their own materials. This is very similar to the debates actually going on about colonial archives, which James mentioned. It's the same viewpoint, the same suspicion of the local terrain and local people. So I think that, yes, this is about the archives as an object, but it's also about a viewpoint. It's about a mentality that underpins a lot of international justice, including the ICTR.
I will turn to this question from the audience, and it is directed to Phil Clark. I will spare Florida for having made a disclaimer that she's not a scholar, and
she is, though.
give it to Phil and James. That Florida, you already
is too modest
to comment on it.
Scholar practitioner, Florida.
Yeah. So the question is, if, as Phil Clark has said, there is a discrepancy between international criminal justice for victims and the inability of international criminal justice to offer economic and political justice to those victimized. What do you think that scholars and activists should do to change instruments of international criminal justice? So you go first, Phil, and then James.
I think we have to be very realistic that it's hard to reform international criminal justice. I think so many of the criticisms being made of the ICC today are the same criticisms that were made of the ad hocs in the 1990s. This is not an industry that changes, that there is an intransigence in international criminal law that means we should be very, very circumspect about its capacity for reform. And I think that's why I want to reorient all of these debates towards the domestic, with all of its flaws, with all of its frailties. I think the future is domestic. I think we have to think much more creatively about not just domestic courts, because that's only one aspect of the domestic space. It's all the other things we've talked about, domestic political reform, socio-economic change, land redistribution, welfare issues, truth commissions, reparations. That's the sphere, I think, where we're going to see a form of justice that is much more meaningful, not just for domestic victims, but for domestic populations as a whole. One of my resentments, I think, about international criminal justice in the last few decades is that it's sucked so much time and energy out of our debates. We've seen it as the dominant instrument, and we have seen most of these discussions through the lens of what is permissible or not permissible through international criminal justice. And I think that we have spent insufficient time looking at a whole range of other possibilities in the domestic sphere. So my answer to that particular question would be, let's give up on the reform process for international law. You're not going to turn that ship around. It is what it is. It's stuck. Look at the ICC now. Under a new prosecutor, it's making the same mistakes as under the first prosecutor. It's wedding itself completely to global power. We're seeing Karim Khan do the same thing that Luis Moreno Ocampo did, dropping investigations into US crimes in Afghanistan, following US political orders in terms of pursuing Maduro's government in Venezuela. It's politicized, just as the ICC was politicized at its outset, just as the ICTR and the ICTY were politicized. You're not going to turn that ship around. It is what it is. We need totally new discussions about justice in the spaces that we have neglected up until now. We've paid insufficient attention to a whole lot of creative options in the domestic arena. I think that's where our time and energy needs to go now.
Phil, you're winning hearts and minds.
Back to pessimism again.
International lawyers who were never that friendly to me anyway. Although, of course, my disclaimer is I'm married to someone who worked at the tribunal, just like you did, Florida. So, she's, Nikki Palmer, my wife, who's also written a great deal on these issues, like Florida, had the kind of, insider perspective on Arusha, and perhaps is not, quite as extreme as me in my critique, but I think is pretty critical of the ICTR, having seen it from the inside. So yeah, I live with these debates as a domestic issue in my household.
I just wanted to come in.
Yes, James.
I agree with what Phil said. I think I think that makes a little sense, and I agree with him that I think the debates should go back to the domestic sphere and find out innovative ways of addressing justice. But I was trying to think of, I think he wrote about it in his book, Distant Justice. The idea of Ntakanda, this guy, the suspect, escaping from all domestic kind of justice system and preferring to go to international criminal court. It's not only him. We also have, I think, one Harun, who is wanted by the ICC, opting that, okay, look, guys, I'm safer. It's better off me going to. What do you think is
I think that's such a great point. Because the ICC,
I'll tell you what it is.
Florida, you say I've talked enough. So
No, go for it. Because
I was just going to say, yeah, you're right. I mean, on Ntaganda, that the ICC's interpretation of Ntaganda handing himself over to the court was that somehow this was a win for the court. And I thought the reason that Ntaganda's handing himself into the ICC is he thinks he's going to get off. He's looked at the standard of justice that's being delivered, particularly the standard of investigations being conducted by the ICC in Ituri. And he thought, I like my chances. I think if I go to The Hague, I'm going to get off because the investigations were so sloppy. So in fact, it was an indictment of the ICC that he wanted to go to the court rather than somehow, a sort of virtuous sign of the court's capabilities.
I agree entirely, actually, Phil.
James,
he did what they call justice shopping.
Yeah, I mean, it didn't work out well for him, right? It did. As it turned out, he miscalculated there because I think his crimes were so egregious and there was so much evidence available that even the ICC couldn't possibly, the office of the prosecutor at the ICC couldn't possibly make a hash of that case. But yeah, he didn't quite get it right in Ntaganda on that one.
And what is your view about go ahead, James. Go ahead.
So, okay, no, thank you for that. Yeah. So you are saying is better off in the ICC simply because the quality of their investigations and trials would, the chances are higher that is going to be acquitted. Let's take the alternative. You being tried in Ituri. What would be your assessment?
Yeah, so and actually, Muleefu, I think this connects, doesn't it, to the next
justice in Ituri.
Yeah, so the Ituri justice
exactly, yeah,
relates to the next question, doesn't it?
Yeah, what?
Alphonse, do you want to ask the next question that has come in from the audience because it links to Ituri, doesn't it?
Yeah, exactly. Yeah. I think you can take it together. We can already take the example of, you can take it as the hybrid courts. But I understand the comment you made, because when, for example, Harun, I think the suspects in Libya, when they were preferring even the son of Gaddafi, his lawyers were advocating that he be tried in The Hague, not in Libya. And I think it was not so much about the fairness of The Hague, but more about the uncertainty in Libya. And he was of the view that probably being taken to The Hague, there is a chance that whatever punishment I might get, it will exclude being killed or something like that. And that was a preference for a suspect to prefer to go to The Hague than being tried in Libya. So, but you may take on that question, Phil.
Yeah, look, I mean, James asks me about the Ituri courts, and it's something I've written on, is that I don't think that any of those Congolese warlords should have gone to The Hague. I think they all should have been prosecuted through the newly reformed domestic judiciary in Ituri. The international community had put millions of euros into rebuilding the court system, the police system, the security system in Ituri. to such an extent that they were starting to deal with very high-profile atrocity cases at the same time that these warlords were being sent off to The Hague. My argument has always been why? Why were these suspects going to the ICC when you had an option right there in Bunia that could have prosecuted these individuals? Now, there are questions about the quality of justice that these individuals would have received in the Ituri courts. In fact, what we've seen through a range of the Congolese cases at the ICC is that the standard of evidence, the standard of investigations there was often very sloppy. So we're not talking about some foolproof international system and some debased domestic system. We're talking about a domestic system that was finding its feet and that I think would have received a huge boost by being able to prosecute these very high-profile cases in their own courtrooms. It would have had a substantial domestic impact in Ituri to have had Lubanga, Katanga, Ngujolo, and Ntaganda prosecuted in those Ituri courts. The other thing that I'll say about the Congolese court system, not just in Ituri, but also in North and South Kivu, is that they have started to do something that the ICC has never been able to do, which is prosecute government cases. So one of the things that is particularly important to recognize about the ICC 20 years into its existence is that it has never dealt with a single sitting member of a state, and probably can't because of its reliance on state cooperation. Well, the Congolese courts have. They now have a track record of tens of middle-ranking and high-ranking Congolese military officials being prosecuted through the domestic system. That is the kind of thing that the ICC should be jealous of. When the ICC came into existence in 2002, one of the things it said that it would do over and above the domestic system was deal with government cases. The argument was domestic systems can't deal with government cases because they're too manipulated by their domestic elites. So you need international justice to deal with government crimes. The reality, at least in a place like Congo, is the complete opposite. The ICC has never dealt with the government case anywhere in Africa. The Congolese judiciary has, because it's gone through this reform process. We now see a much more effective Congolese judiciary than we saw 10, 15 years ago. That should give us pause for thought, I think, about ultimately where we think these cases should be going. And again, I think the momentum is in the domestic realm.
I think we would be moving towards the closing our conversation. And I will go first with the James. What would be your parting words? You know, it's not in one sentence, but in 5 minutes, because we have 20 minutes left. In case there is a question that comes in, we will put it in. But in 5 minutes, tell us from this conversation, what should we take home?
First, I think is that we should strengthen the legal and the political will at domestic level to prosecute atrocity crimes. That's the first one. Then the second one is that I think there should be more dialogue between the proponents of what I have said, the hegemonic global justice system dominated by the West and Western interests with a domestic justice system. And I wish we could see more of what happened in Rwanda. That Rwanda had a situation, a challenge, and they wanted to find a solution. They found their own solution, and then they defended and showed that it worked. So I think if many countries, especially in Africa, as a way of pushing back interference from what we have, what I consider to be manipulated justice, international justice system, they should take the initiative and take the responsibility. Yeah, I think that's all I can say. And the more we can have dialogue, mutual dialogue between proponents of international justice system and those ones of local justice system, I think we can come up with, like what you asked me, a much more acceptable instruments of justice to deliver accountability, especially for those ones who have suffered atrocity crimes. I think that's all I can say. Thank you. Thank you.
I will go back before I ask the other two panelists to give their parting shots. I will want to ask this question. Phil, I want you to reflect on these mass graves of indigenous children that have been discovered in North America, both in Canada and US. And try to put it in the context of justice and all this conversation we have been having. I will come back to you to close, but I want you to at least, I think it would be unfair not to talk about it. You could maybe to phrase the question differently. How old is a crime too old to receive justice?
Do you want me to answer that one now, Alphonse?
Yes, please.
Yep. No, you're right. I mean, I think this is one of the really important developments in justice debates in the last few years, is that finally we're talking about the global north. For too long, we thought that these justice discussions were only about the global south. I say this as an Australian. I say this as someone coming from a society that I don't think has even begun to have the kind of justice conversation that we need to have, whether that's about British colonialism, whether that's about post-colonial crimes against our indigenous population. We haven't even begun that dialogue. Societies like the US, Canada, European former colonial powers, Belgium, France, the Netherlands, Spain, Portugal, they're all Johnny-come-latelys to this discussion. There's a much more sophisticated justice discussion happening in places like Kenya, Uganda, Rwanda, than there is in those global north societies. That they're finally catching up with that. And I think the thing that they're realizing is that there is no statute of limitations on dealing with those historical crimes. Those are the ghosts that haunt all of those societies, whether they are the colonizers or whether they are the settler colonies like the US and Canada. Those societies have pathologies built deep within their social fabric because they have refused to deal with those historical atrocities. And it's only now in the 21st century that they're starting to deal with those. I hope that Australia gets there too. We're not there. We're not even close to that yet, but I hope we get there too. And it's ugly. These are societies that are having to face up to their really ugly pasts, what they did, who the victims were, where the bodies are buried, all of those very visceral remnants of that difficult past, and are now having to ask themselves, what will justice look like in that particular context, given the gravity of those crimes and given the time that has passed, the fact that many of the survivors are no longer with us. What does justice look like in those situations? I have some hope for Canada. I detect that in Canada, there's some honesty in the political environment there to actually start to deal with some of those crimes, especially those committed in the residential schools. I'm not so sure about the US. I think it's fleeting. I think it's fragmented, the justice response there. You know, there are lots of groups and lots of powerful voices calling for accountability, especially for crimes committed against the African American population and also against indigenous Americans. But it hasn't coalesced into a really coherent movement with serious political momentum behind it. So we have to keep an eye on the US. We have to hold the US's feet to the fire on these issues and demand that it goes down the justice pathway that it has demanded of so many other countries around the world. And the European colonial powers, my fear there is that this is cosmetic. My fear in places like Belgium and the Netherlands is that they think that it's the right thing to do to be seen to be doing justice, but without really following through on it. My fear is that their view of what justice for colonial crimes means is you return a few artifacts, you hold a couple of commissions of inquiry, but you don't really do anything else. You definitely don't pay systematic reparations. You definitely don't make systematic apologies for what you did. You do the bare minimum and then you hope that it goes away. So I'm glad that we're having these debates in the global north. I'm concerned by the lack of substance in some of those global north discussions. And I wish that the global north would learn from, for example, some of the Central and Eastern African states that I think have had a really serious, systematic, painstaking debate about what justice means over the last 20 or 30 years, that the global north needs to learn from those kind of lessons.
James, I can see you feeling like you want to come back, even if I said give the parting shot. James kept himself muted.
No, sorry. It's true that I think it's long overdue for the global north to have serious discussions about the historical injustice that they committed, especially in the global south. And I agree with Phil that there's lack of substance in the nature of discussions that they are having. And maybe I can explain possibly why. It's because the perpetrators seems to be leading the discussions themselves. The voice of the victims are nowhere to be found. So I think that's could possibly explain that, because if they are the ones who are deciding what is good for the victims, I think the risk is that they cannot be their own judges, right, for what happened. So it's up to the global south to come up with that movement. And there has been, it's there. I think it's there, this movement towards historical reparations and so forth, but it's very fragmented. And this is an interesting area where I've seen the global north trying to justify justice in terms of socio and economic justice approach, where they say the aid that we give to Africa is part of reparations, right? They are not looking at individual criminal responsibility or the civil and political, that individuals should be held accountable. So they say, when they give us aid, we should, it's a way of acknowledging the injustices, which is a very weird and patronizing way of looking at justice systems, in justice for historical injustices. Thank you.
I want to read out this comment so that as Florida and Phil Clark are giving their parting shots, they may also reflect on it. The question is justice just about transfer of power, or is it something more? How are we able to use existing European hegemonic justice system to address power imbalances between the global north and south? As we come to the conclusion, I give the floor to Florida. You have 5 minutes to comment on all this conversation that has happened between Phil and James, and something about this comment, but also you give us your take home.
It's very difficult to reconcile what we've been talking about, that is mass atrocities that happened in the past, that have been kind of addressed, and then the current issues that are actually happening in the global north. We've all been made to believe, and I think it's a smoke screen. The narrative is always dictated by powerful states. Obviously, they are doing everything right. And in fact, what has happened is an explanation for it, which is they gloss over everything. It's, while whatever happens in the global south is basically taken as, what else would you have expected? And the condescending discussion that James is talking about is that the systems in the global north are perfect. They've been going on for so long. We should emulate them with their perfectionism, while they're completely imperfect for us. So there needs to be a discussion and an understanding that the global south has its own systems that serve a purpose. And there needs to be respect. When mass atrocities have happened, usually the people that are affected, they actually have an idea about how it all came to be and how it can be resolved. They're not stupid. They may speak a different language. They may speak with accents, but they do know what's best for them for the most part. So there needs to be a discussion and an understanding there needs to be given room for them to find their own solutions. And the idea that when you're given aid, it translates into reparations is actually completely ridiculous, because to be quite honest, when you talk about the plundering of resources that has happened historically, and then you're throwing up back things about aid, and then you should be quiet. I mean, we can have a discussion for days about how European cities were built, with whose resources. So the condensation, if we wanted to have it on our side, we could have it as well. We built it with the human resources of our continent, the slaves. You took resources, natural resources from our countries to build your cities. And then the condensation of our systems, no better, they should. If you look at the situation of Rwanda, we not only use the Chacha, but the normal court systems. We had things about reparations, where perpetrators were actually doing work and doing things that were actually leading to reconciliation. You had pardons eventually coming in. You had funds for survivors. You have all these socio-economic things that were happening. It was a whole solution of things under very, very difficult circumstances, most of the time against the wishes of the powers that be. But it was done, and I think tailor-made solutions for different situations ought to be given more impact than what is happening right now. And I think there need to be more voices of people speaking up to this and challenging the global north to do more listening than dictating. Thank you.
Phil, we are left with 8 minutes. I want to give you 6, so that at least you leave me with the 2 to close.
No,
so the floor is yours.
No one needs to listen to me for 6 minutes. I can assure you that, Alphonse. Look, I'm not sure I can say it any better than Florida in that sense, that I do think there has to be a lot less dictating from the global north to the global south. I would come back to that experience of Colombia learning from Rwanda. I think there's something so powerful in that experience that Colombia was getting advice from all over the place, not least from the ICC, which had opened preliminary investigations in Colombia and was telling the Colombians they had to have a version of criminal justice in the context of the peace talks that looked like the ICC. And if they didn't, they were going to be subject to ICC intervention. The Colombian response was to kind of hold their ground. The Colombians, trying to negotiate a transitional justice mechanism in Havana, said, that's not going to work for us. If we go down the line of maximum prosecution, the FARC will walk away from the peace talks and the peace process will collapse. So let's look around the world and let's see if there are creative examples that we can build a different justice model on that will work for us. And they found that in a place like Rwanda. That might be one of the most significant exchanges in justice circles in the last 20 years. The Colombians sent a delegation to Rwanda. Rwandan delegations went to both Havana and to Bogota. And what the Colombians have come up with is a really sophisticated, contextually specific justice mechanism or set of mechanisms that work for them, that keep the FARC and the government in a dialogue, keep the country in some kind of peace, and deliver something that looks like accountability. And they learned those lessons from a tiny state in Central Africa. They didn't learn it from Harvard or Oxford or The Hague. They learned it from villages on the hills in the Rwandan countryside. And I think what that says to me is contextual justice can be found in all sorts of places if we're willing to be creative, if we're willing to be open-minded, and we're willing to throw out some of our templates from the past and start again. Now, what's interesting, and I'll end on this point, Alphonse, is that the ICC recently ended its preliminary investigations in Colombia. It basically said to the Colombian state, we're okay with this justice model. We don't really like it, but we're okay with it. They're incredibly patronizing in saying that, by the way. The wording of the ICC statement was remarkable. It was, we are reluctantly going to withdraw. Basically, we've been hovering around here too long and we're not getting any traction either. So it's probably right that we go. But we're still keeping an eye on you. We're not so convinced that this new model of justice that you've come up with, this Havana deal, is really what justice is supposed to look like. So don't think you've gotten away with it yet. To which the Colombians have basically shrugged and said, we're just going to get on with it because we've got a job to do. We're trying to put our country back together. We're trying to get the peace process back on the road. We're trying to do justice in a way that makes sense here. And we've still got Rwandan voices in the back of our mind telling us that we've got to stand our ground. I think that that's important for Colombia, but I think there's a global message there as well about societies thinking creatively, thinking contextually, and being willing to do so even when the international community makes it very difficult for them to do that.
Ladies and gentlemen, this concludes our discussion. Thank you to you, our panelists, your critical insights, your suggestions, your questions, and your wonderful work. Thank you to the Center for Criminology and Social Legal Studies at the University of Toronto, and thank you to everyone for your participation. If you would like to have more information about the Salon series or the summer school in Rwanda, please visit the website listed in the event description below. The theme for the next Salon is engaging international human rights in the aftermath of the global crisis, and will be held on Friday, February 4th, 2021. Tickets for that Salon will be available on our Eventbrite starting today. We are ending with some 2-3 minutes early, but I think we have touched on almost all the aspects we wanted to cover in this discussion. So thank you very much, and have a good day or evening, depending on where you are. So thank you very much.
Thank you, Alphonse. Bye, everyone.
Thanks, Alphonse. Thanks, James. Thanks, Florida. A pleasure.
Good seeing you again, Phil.
Always a treat. Always a joy.
Thank you.
Plenty more to talk about.
Thank you, all of you. Thank you.
Yeah. Thank you, Muleefu. Thank you so much.